5 seconds to go. Start. A two-judge bench of this court dealt with the question as to the matters that could be considered by the High Court in quashment proceedings under Section 482 CRPC. It was held therein that statements of witnesses recorded under Section 161 CRPC, being wholly inadmissible in evidence, could not be taken into consideration by the court while adjudicating a petition filed under Section 482 CRPC. In that case, this court took note of the fact that the High Court was aware that one of the witnesses mentioned that the deceased victim had informed him about the harassment by the accused, which she was not able to bear and hence wanted to commit suicide. Finding that the conclusion of the High Court to quash the criminal proceedings in that case was on the basis of its assessment of the statements recorded under Section 161 CRPC, it was held that statements thereunder, being wholly inadmissible in evidence, could not have been taken into consideration by the court while adjudicating a petition filed under Section 482 CRPC. It was also held that the High Court committed an error in quashing the proceedings by assessing the statements recorded under Section 161 CRPC. There can be no dispute with respect to the position that statements recorded under Section 161 CRPC are inadmissible in evidence and its use is limited for the purposes as provided under Sections 145 and 157 of the Indian Evidence Act 1872. As a matter of fact, statement recorded under Section 164 CRPC can also be used only for such purposes. In the instant case, a scanning of the recitals in paragraph number 10 of the impugned judgment would undoubtedly reveal the fact that the High Court had formed an opinion on perusal of the statement of a teacher of the victims and also the statements of the victims that sexual assault was detected only from the General Hospital Chandrapur and then arrived at the conclusion that the respondent was not made aware of sexual assault committed on the victims and there is no evidence to implicate him in the said crime. Paragraph number 10 of the impugned judgment reads thus: in the above backdrop, we have gone through the statements of victims which have been referred by the prosecution. The statements show that the applicant had examined the victims. Their condition was deteriorating. Therefore, they were sent to General Hospital Chandrapur. There is no material on record to show that the applicant was made aware about the sexual assault committed on the victims. On the contrary, from the statement of the teacher of victims, it appears that the sexual assault was detected only in General Hospital Chandrapur. Therefore, we are of the view that there is no evidence to implicate the applicant in the said crime. Therefore, the continuation of proceedings against the applicant would amount to abuse of process of court. Thus, a bare perusal of the above extracted recitals from paragraph number 10 of the impugned judgment would reveal that the High Court had gone through the statements of victims' witnesses cited by the prosecution to arrive at the conclusion as to the existence or otherwise of evidence against the respondent. In view of the provisions referred above and also plethora of decisions including the decisions in M.L. Bhatt's case supra and in Rajiv Kaurav's case supra, statements recorded under Section 161 CRPC are inadmissible in evidence and therefore could not have been made the basis for arriving at such conclusions. As noted above, the FIR carries suspicion of commission of sexual assault and the charge sheet reveals prima facie against the respondent in relation to non-reporting of such an offence under the POCSO Act. The very case of the appellant is that some among the 17 victims have given statements under Section 161 CRPC and some others under Section 164 CRPC specifically stating that the respondent was informed of the sexual assault on them. When that be the position, we have no doubt that the High Court should not have embarked upon an inquiry, especially by looking into the statements of the victims recorded as also their teacher to form an opinion regarding the availability of evidence to connect the respondent with the crime. True that the FIR and the charge sheet still remain in effect in respect of the other accused. But then, non-reporting of sexual assault against a minor child despite knowledge is a serious crime, and more often than not, it is an attempt to shield the offenders of the crime of sexual assault. Be that as it may, in view of the decision in Shankar Kishan case Supra, holding non-reporting of such a crime as serious, and in view of the position obtained from a conjoint reading of sections 19(1) and 21 of POCSO Act, such persons are also liable to be proceeded with in accordance with law. Stop.